Thank you very much. Mr. Skibine and Ms. Coleman, I get the impression from your statements that you think that perhaps the danger here has been somewhat exaggerated. Is that the problems have been somewhat exaggerated? Is that accurate?
Well, I don't think that there has been the problems in the past. As my testimony indicates, we've essentially followed IGRA very carefully, and it hasn't resulted in that many casinos proliferating everywhere. I think potentially we are concerned about what's in the future because of the potential for abuse that is there under the Act currently. But we haven't seen that. As I said, we're not really with some of these. To us, they're just rumors, and we have no involvement, so we don't know for a fact that that's an issue.
Which means that perhaps some legislation may be necessary in order to prevent some of these things from happening. Do you agree with that?
It may be. I mean, we would be, and as I stated, we would be willing to discuss with you what would be the appropriate mechanism and where it needs to change to tighten things up.
We need to do that, but let me just give you examples of why there seems to be concern. Stories about a member of the Bureau of Indian Affairs that had literally signing recognition papers on his way out the door or in his car. I mean, I think that's fact. Those were rescinded because of the circumstance of his last day in office. Rumors or stories that are carried that a tribe is willing to trade their claims for half of the state of Colorado for, as Byron Dorgan mentioned, so they could establish a casino in downtown Denver. When these stories start circulating like that, people are asking, what's this all about? You see my point?
Yes, and that is an issue. And I was in Colorado. The governor of Colorado had a meeting or a conference regarding that, and I think it's a real issue. With respect to the Colorado issue, I think the department has determined that the claim that is asserted by the tribe is not genuine and lacks merit. So for purposes of the settlement of a land claim, the reason we have only had one so far is that our view is that the settlement of a land claim has to be a settlement that is ratified by Congress. So as the Seneca claim was. And as a result, there is a phenomenal check on an abuse of that exception. If it has to come before this body, and essentially it will be scrutinized to the nth degree, so that their settlement legislation is not enacted willy-nilly here.
So Senator Voinovich's concern about a casino in downtown Cleveland his concern is not as compelling as perhaps we might think.
Perhaps that's right, because it would have to, in our view, there would have to be settlement legislation introduced in Congress. Now that is our view, and we have a solicitor's opinion that states that. Now potentially, some tribe may disagree with the view of the Interior Department on that, and challenge in court if they apply for a settlement of a land claim, and we say you don't have congressional legislation, goodbye, and they may sue us because of that. Maybe. And so I don't know where that would go. Maybe the Act could be tightened on that score to make sure that we're talking about settlement legislation that is ratified here.
Let me go back with you to one of the fundamentals. When IGRA was passed, it was, as we all know, it was as a result of the Cabazon decision. Said that if a state allows a certain level of gaming, then Indian tribes that reside within that state would certainly have the right to engage in gaming at that level. Isn't that's a proper interpretation of the Cabazon decision in your view?
Yes, that's correct.
But then there was a decision that was made that if a charitable organization has a Las Vegas night once a year where gaming is conducted, therefore you can have a 24/7 12-month-a-year gaming operation on an Indian reservation. That changed things rather dramatically, didn't it?
Well, yes, the view of the department is really to follow the decision of the Ninth Circuit in the Rumsey decision that was appealed to the Supreme Court. The cert was denied, but I think the SG filed a brief in support of that decision. And under the Ninth Circuit reasoning, I think that the scope of gaming has to be by activity, so that for instance, the issue there was, let's say the state of California authorizes horse racing, which is Class 3 gaming activity. Well, that would mean that all Class 3 gaming activities are open, like the slot machines. And the court said no, it has to be, that gaming activity has to be authorized, and that's our view right now. So that.
But that's not responsive to the question that the senator asked. He asked the question about a state that allows a Las Vegas night once a year and the
charitable purposes.
Charitable purposes.
Right.
And the consequences of that, of triggering an opportunity in the state for the brother.
That's correct, because charitable gaming is nevertheless gaming, and if that gaming activity is authorized by charities, then it will be authorized for Indian tribes under IGRA. That's I think that's our view, and certainly would have been the view of the courts right now.
Is it the department's view that the land claim exception authorizes a tribe to open a casino in geographic locations it's not been possibly more than 100 years? In other words, you mentioned, or Ms. Coleman mentioned, that one of the reasons why they didn't approve of Kansas acquisition because they had passed through, or you mentioned that. In other words, what's the criteria here? Many of these tribes tragically moved all the way from our east coast out to the west, not of their own volition, by the way, but they had various stops along the way.
Right. The settlement of a land claim, which I said we have tried once. I think the way that would work is that the settlement legislation that is introduced in Congress, and if it's eventually passed, will in all likelihood specifically say we settle this land claim, and as part of the claim, the Secretary of the Interior is mandated to take land in trust in blah, and we'll probably specifically say where it is. By county or even by lot, so that in the Seneca Land Settlement Act, for instance, it was specifically stated in the act where the land could be taken into trust, and that's what we would be looking for. So it's what we think is really not really important, because we would be following what Congress tells us to do in the settlement legislation. With respect to the Eastern Shawnee, if there's legislation that says Congress sells the claim, and in exchange, for whatever reason, but the Secretary has to take land in trust in Ohio in specific community, then we'll have to do that. But we will look to you to tell us how to interpret the law.
Ms. Coleman, sounds to me like you could use some more help.
Absolutely.
Thank you very much, Senator Dorgan.
Ms. Coleman, let me ask a question about licensing. If I'm a tribe and there aren't any of these land issues, and I just want to open a casino, and our state has gaming, and so I want to develop a compact, I have to get a license from whom?
From the tribe's regulatory authority.
And so that license, based on your testimony, that license may be granted before, in other circumstances, before land claims are settled?
Well, as Mr. Skibine testified, the settlement of a land claim exception is so rare, it's only happened once, that, it really hasn't come up. The one time it did come up is the same Wyandotte, Kansas situation where the land was already acquired into trust, and the tribe argued that acquisition was a land claim, settlement of a land claim. And we determined that it wasn't, because it was an ICC act. There was an ICC case, And we concluded that ICC cases are not settlement of land claims, that they're settlement of money damages against the federal government, but not actually for settlement of a land claim.
But with the size and the growth of Indian gaming, my expectation, and I assume yours would be, that these things will come up more and more often because the stakes are so high. Let me just mention, Mr. Chairman, last evening, or yesterday late afternoon, we finished the Interior Appropriations Subcommittee. I'm the ranking member on that. We finished that piece of legislation, and my colleagues from Oklahoma were trying to, and we weren't able to do this. I wish we had been, but weren't able to put this in an appropriations bill. But there's an issue, which you're probably familiar with in Oklahoma, dealing with the Shawnee Tribe Status Act. That act was passed, and somehow it gives the Shawnees, this is according to the senators from Oklahoma, it gives the Shawnees the ability to take land into trust, so long as it doesn't interfere with other tribal jurisdictions, and requires the Secretary to approve the land in trust, shall versus may. And they say this loophole would allow the Shawnees to take land into trust within Oklahoma County, in the middle of a major city, and the Secretary would have to approve it. And they say that circumvents existing law and regulation on normal land in a trust application, and they feel that's a self-executing circumstance currently in law. They're trying very hard to change that.
Which I might add was put in an appropriations bill.
Right.
Omnibus appropriations bill.
Right. So, but my point about this is there's a powerful reason for tribes to try to find ways through these exceptions to locate a casino in the middle of a major population area. I understand that. And if we were able to, and our purpose was to be able to run a casino, we would want to be in the middle of a population center. That's a natural market. And yet, we have certain guidelines and restrictions, and we rely on our regulatory agencies to deal with them appropriately. We also rely on the Congress to make the right decisions on these things. Occasionally, we don't make the right decisions, but I think one of the things that I've learned from your testimony, Ms. Coleman, is that this issue of the resources that are available to respond to the needs to effectively regulate a very growing industry is an important consideration for this Congress, and I think we need to get additional information from you. You indicated that you haven't really had a system by which you move things out the door, make judgments, and move things, but you're now developing that system. I would say hurry, because I think there's going to be enormous pressures from many different directions to find ways through the exceptions. Well, Mr. Chairman, I have to leave at 11, but I know that we have another panel coming on. I'll be able to hear part of that panel. But I thank the two witnesses. Mr. Skibine, thank you again for being with us, and Ms. Coleman, thank you.
Thank you.
Senator Smith.
Thank you, Mr. Chair. Thank you, Mr. Chairman, and Senator Dorgan. Mr. Skibine, in May you testified that IGRA's two-part determination suggests that Congress sought to establish a unique balance in determining exceptions. Only 3 tribes, as I understand it, have acquired exceptions under that provision since 1988. But those are in-state, and yet a lot of concerns remain. My question is, would restricting the two-part determination exception only to in-state lands remedy most of the concerns that remain?
I think it will help remedy some of the concerns. I don't think it will certainly address the issue with the settlement of a land claim that was raised by Senator Voinovich here. That tribe would be taking exception of another exception, the settlement of a land claim exception, where there is no restriction on state boundaries under that exception either. The fact is, we of course have only approved three two-part determinations for tribes since '88, all within the state where they are located. We currently have 8 that are pending, and of those, I think all are within the state where they're located, except for one, which is the Stockbridge Muncie community of Wisconsin, At this point, that application is for land in the Catskills, and it is submitted as a two-part determination for land in New York. But in fact, I think that if this goes through, it probably would go through as a settlement of land claim rather. So in fact, if you discount this one, we really don't have any that are pending under the two-part determination for out-of-state tribes.
Question for both of you. I think one of the most unseemly things that has happened on Capitol Hill in a long time, frankly, seems to grow out of IGRA and the number of developers apparently seeking Indian tribes to pursue gaming interests, and frankly, that has led to some very shameful things happening. These developers often are looking for a tribe. They pay for the lawyers. They pay for the upfront lobbyist costs. I wonder if this is just perceptual on my part, or are you seeing more applications that are driven by these kinds of non-Indian interests on behalf of tribes to pursue their gaming interests?
I'm not sure if there is an increase in that. I think if you look back to some of the earliest applications, they were also, the tribes were supported by outside developers. Let's take, for instance, the Mohegan tribe of Connecticut was supported by a large gaming corporation out of South Africa, and I think that part of the reason for that is that some of the tribes that are new tribes especially have very little means and essentially are pretty much penniless on their own, and I think it's not necessarily what they want to do to come into a partnership with an outside group, but it's certainly something that is, when it's offered, they can see it as an easy way to access capital and to essentially move their applications along and move their plans along. Whether there's an increase, it could be based on what is, the rumors that are out there, but we don't really have a handle on that specifically at the BIA. I'm not sure. Maybe the commission can address that.
I don't know if there's an increase. We do know that the harder we make it for tribes that are landless to get land into trust, the more dependent they have to be on the outside resources. Because tribes that don't have money have to go through the process, who have to go through the department, go through the NIGC, to acquire land into trust, to get it to be designated Indian lands. That takes time, that takes money, and so they need to look to the outside interests. And in some of these, as I said earlier, they're very difficult. They do take a lot of money. If you have to hire an ethnohistorian, if you have to hire an environmentalist to do all of the NEPA work and the prove it's restored lands, it's going to require somebody to put up the money.
I assume though that there's a concern in the Interior Department about it. Is there any effort made to identify the tribal interest from the developers' interests and to provide some level of direction that gets in the way of some abuse of tribes?
We definitely are aware of that issue all of the time. We want to make sure that tribes that they don't end up in a situation where it's not really the tribes gaming anymore. And it's one of the driving forces behind our sole proprietary interest advisory opinions that have kind of tried to draw a line, say, tribes, if you give this much of your gaming to this company, well, then you're no longer the sole proprietor of this. You have to retain the bulk of it. The IGRA is intended for tribes. They're to be the sole beneficiaries. And so So we've taken a pretty hard line on this sole proprietary interest issue, and I think it's really helped. And we've also they have been talking to the Senator McCain about more background investigations for a larger number of people who are involved in gaming. I think that makes a lot of sense. You want to make sure you have good guys in gaming. A lot of tribes do really good background investigations. Not all tribes have access, though, to like the FBI criminal history checks and the fingerprint checks and all of those kinds of things that the federal government has access to.